Terry Strickland versus Getz. Ms. Parker, come up, please. All right. All right, we have it on the calendar for motion for a modification of custody, motion to dissolve the parental rights of the plaintiff, and motion for summary judgment. Any other motions, preliminary motions prior to calling the case?
No, Your Honor.
Getz, anything prior to calling the case? Motion.
Another motion for removal of parental rights.
Your parental rights, or? All right. All right. So how does motion break down? Y'all's motion for modification of custody, or?
No, Your Honor, all the motions were filed by Mr. Getz. An order was entered, actually a temporary order, back in October 14, 2002. And our position is that by operation of law, based on neither party petitioning the court for a significant period of time, that becomes a final order.
Oh, the earlier order, how long was that in effect?
It's been in effect now for almost 7 years. Now, Mr. Getz has filed a motion to terminate parental rights. I don't think the court needs to spend very much time on that, because there's really no legal merit to it. There's a procedural process to terminate individuals' parental rights, and that's set forth in Chapter 7B, and there's just no legal authority at all to address that here today. I don't know if Mr. Getz has any legal authority at all to support that position, but I would say...
Are you saying it's fact, or are you saying...
I'm saying it's a legal matter. I mean, in order to terminate parental rights, you have to file a petition to terminate legal rights. It's got to be verified. It's filed under Chapter 7B in juvenile court. It's not filed in a Chapter 50 proceeding. Aside from the legal aspect of it, it is absolutely meritless with regard to facts. But we can spend a significant amount of time dealing with facts, but as a threshold matter, from a legal standpoint, it's not maintained.
Filed a motion to terminate under Chapter 50?
He filed it in this proceeding as a motion in this court.
Mr. Getz, is that correct?
Well, sir, there's a number of things we spoke about I'd like to reply.
Well, I'd like to first of all know if you filed this in juvenile court, or you filed this as part of Chapter 50, which would be in custody.
Being not an attorney, I basically filed in response to the judge's hearing.
Well, you're going to be treated as if you are an attorney representing yourself. You understand that, right? Yes, sir.
The fact that it's taken 7 years is not in my control. I moved here with my daughter from Texas 7 years ago. I thought we were going to be married in a family. After I got here, they turned against me and put me out on the street. And I was put basically on 7 years now, been fighting to get off the street. I finally got back on my feet. During that time, I've been maintaining a relationship with my daughter. I know I'm not an attorney, and there might be mistakes in my case,
But what has to be done is what's best for my daughter. And I have solid evidence over a long period of time that her mother has not acted in a condition that is appropriate of a good mother. And I hate to have to do this, but I have to be able to get my daughter her safety and her health in check. As her father, I have both the obligation and the responsibility, losing faith in her mother, to have to stand up and do this. I ask the court to recognize her actions and how it has hurt my daughter. And I ask the court to help make sure my daughter is okay.
Well, certainly that's a paramount interest of the court, but under some recent case law, I mean, it'd be very clear that a temporary order entered in October of 2002 would be considered under some recent case law to be a permanent order to require you to show up.
Sir, I had no control. I was living on the street. It was impossible for me to be able to do anything. And now I must do so. Knowing the facts that I do about her mother and the way this has all gone down, my daughter is not safe with her and her family without me there. I'm doing the best I can. I actually overlooked some proceedings and the effort to make sure my daughter is okay.
Well, I'll certainly do that, but I can't overlook procedural problems you have in filing it. First of all, your motion to terminate parental rights.
My effort is only to establish control of my daughter, not take her away from her mother. At this point, for 7 years, I've been kept from her, and it's hurt her. And I've waited patiently for some changes on her mother's behalf and her family. They seem incapable of doing so. I have to establish control to make sure she's okay. At that point, I'd be happy to make sure that she has her mother and her grandfather again. I'm not trying to keep anybody apart, but as long as she's in control, this is the way it's going to go, I'm sure.
All right, well, your motion to terminate parental rights is denied. Is that what your motion for summary judgment is?
No, Your Honor. Mr. Getz, on an issue of custody, has filed an unverified, unsupported motion for summary judgment. As Your Honor is aware, a custody determination is very factually specific. It's not the kind of case that is even susceptible to being decided by summary judgment. Even if it were, Mr. Getz has not supported his application with anything other than a signed motion, no affidavits, no nothing. So we would ask that that motion be denied as well.
Mr. Getz, you're saying when you file a motion for summary judgment that there is no material issue in the case. There's nothing for the parties to fight about.
Sir, it's my intent to try to solve this problem before I have to prove my case. I do not want to be here to talk bad about my child's mother. I'm trying to make sure she's okay. There were two big issues that were a problem with the current ex parte custody order.
Well, let's don't get into that part. The issue here in the summary judgment motion is whether or not there's an issue of material fact between the parties. When the parties agree on whatever is at issue, then a motion for summary judgment is appropriate. In other words, you owe me $10,000. Yes, I owe you $10,000. I just can't pay it. That would be an appropriate for motion. But here you're saying something about them. They're not agreeing with it.
No, sir. My summary judgment is based on the fact that we were not residents here for 6 months. The court order is invalid, and I believe that's a statement of fact. There's nothing to argue about. It's back in their legal paperwork. We were here 2 months before I was put out on the street.
Your Honor, the parties have lived with this order for almost 7 years. This man has been exercising visitation for almost 7 years. And now here we are on his motion to modify custody. He wants to argue, I guess, that there's no jurisdiction here, which is without merit at all.
The court requires 6 months residency before you have authority. We were not here 6 months. The order is invalid.
And, Your Honor, if you follow that logic to its end, then what would happen is we would simply vacate any orders in the case presently, and then we start back from square one. And that, I would submit, is just not what the law requires.
I agree that a custody arrangement at this point would be best for my daughter, but I cannot deny the fact this order is invalid.
All right, motion summary judgment denied. All right, so that leaves us with a motion for modification of custody. Is that your motion?
Yes, sir.
All right.
Ex parte custody order.
Well, at this point, it's a permanent custody order. under the law of this state. All right?
It's the only order in place, so you're saying the ex parte custody order is permanent, and that's what I'm asking to modify.
That's the order of October 2002.
No, there was an ex parte custody order that became a permanent order. You actually were temporary order back in October of 2002. Your Honor presided over the case then and entered an order. So we don't have an ex parte order any longer. We have a temporary order, which, again, arguably from a legal standpoint, is a permanent order.
You may put on evidence to change the order, but at this point, it's a permanent order under the law of this state. After 7 years, or just about 7 years, it becomes a permanent order. Okay?
And I asked the court to modify it, take into consideration my evidence for a mother's action, and allow me to have my daughter back.
Right. It's at this point you have to put on evidence. You ready to do that?
Yes.
All right. We'll call you first witness.
Yes, sir. I'd just like to make opening statements and then go from there.
You got 2 minutes.
Yes.
Your Honor, before we get into his opening statement, on the calendar it's indicated 2 hours allotted for the case. Is that going to be?
That's correct.
Okay. So each side gets an hour, including cross-examination, goes against each party's respective time.
That's correct. Okay. All right, you got 2 minutes for an opening statement. You may proceed.
This day has been a long day coming for me. I wish I were not here. I wish we did not have to go through this. I have tried every way that I know to make sure that my daughter is okay and to get along with her mother. My name is Michael Lee Guest Sr. I am the father of Stephanie Ann Guest. Her mother, Sherry Strickland, and her family invited us here after our child was born. In my mind, as I understood it, to be a family. We were engaged. We came here to be married. Shortly after we arrived here, they turned on me. I was jumped, beaten, and put out on the street, forced to the street. The last time I saw you, you gave me 48 hours to get out of my house. I ended up in a homeless shelter living on the street. For 7 years, I have struggled to survive. I have maintained my contact with my daughter 3 times a week. Sometimes riding a bicycle 30 miles round trip in all kinds of weather just to spend an hour with you. This situation is absolutely wrong. I tried everything to get along with no chance of any differences. I come here today not to speak bad about Miss Strickland. She's the mother of my child. I never wanted to be here. But as her father, losing confidence in her ability as a good mother, I have both the obligation and the right to step up here and ask the court to give me my little girl back. I was there when she was born. I took her to vocal court. I saw her and she saw me. I was the first thing she saw in this world. I took care of her every day until we came here and had her taken from my hands and put out on the street. I am the primary care provider by every definition, except that she made more money than me. It is in the best interest of my daughter for me to maintain control of her life to make sure that she has family, not be destroyed as Ms. Strickland has done. I have brought evidence, and I provided to the court and the attorneys on the things that I'm talking about, and it is pretty. I do not want to have to show evidence of this, but I will. I ask the court to modify the custody order and give me my daughter back. As her father, I have obligations that I must do, and with this current situation, it doesn't change. My daughter's health and future is at stake. That's my opening statement.
All right. Thank you, Mr. Gibbs. All right. Any opening statement?
Yes, Your Honor. Your Honor, Stephanie will be 10 years old in December. This order's been in effect for 7 years. During that time period, Ms. Strickland has been the primary caregiver. This little girl attended Montessori school for a time. This little girl is now attending Aiden Elementary School. The evidence is going to be that she's doing very well. She's got extended family here in Pitt County. She's got cousins. She's got aunts, uncles. She's very well adjusted. She's happy. Since 2002, Ms. Strickland has provided almost all the financial support. The evidence is going to be that up until a child support claim was commenced in, I think it was September of last year. Mr. Getz paid a grand total of $520 in child support over that entire 6+ year time period. Mr. Getz is coming into this courtroom saying that this is my child, and he goes so far as to file a motion to terminate parental rights. Ms. Strickland has done nothing but right by this child. Ms. Strickland's father, who was in his 70s, 3 times every single week over the last 7 years has accommodated Mr. Getz with this custody order. Now, standing here today, I think Ms. Strickland, of course, will tell you that she feels like a modification would be appropriate. The child is almost 10 years old, and she'll tell you what she thinks is appropriate. But in terms of modifying the custodial arrangement, in terms of who's primary custodian, the evidence is going to be conclusively compelling that no such modification is warranted. And we ask that the court deny Mr. Getz's motion to modify in the sense that he's trying to change primary custodians. We're not opposed to a modification being made in some respects. It will accommodate and take into consideration the child's age and things that have occurred in the last 7 years.
All right, well, both parties, the ground rules are that you've got an hour apiece to put on your evidence. That includes questions that you ask the other party, okay? So when you cross-examine the other party, that counts in your hour, okay? We have a number of cases after this, and we keep everybody in line, and we'll proceed as quick as we can. All right, Mr. Getz, since you're the petitioner, you may proceed to offer any evidence you wish to offer. You have to do that under oath. You have to come up and do that under oath, okay? You want to bring any of your papers with you? You certainly can do that too, okay? All right, if you'll put your left hand on the Bible and raise your right.
Yes.
All right. You can have a seat right there. All right, for the record, if you'll state your name for the court, please.
I'm Michael E. Getz Sr.
All right, and you may proceed.
As I said in my opening statement,
First of all, where do you live?
6202 Turnage, Farmville, North Carolina.
How long have you lived there?
About 5.5 years.
All right. You
As
may
I said,
proceed.
sorry?
You may proceed.
As I said in my opening statement, the reason I've asked this today is not out of anger to hurt anyone. It is because I've lost confidence in my child's mother to make wise decisions in regards to my daughter. Over the last 7-8 years, I've collected evidence on the things that have gone on, and it's for those reasons that I had to come here today. Some of the things that have bothered me since I met Miss Strickland, back after she was first pregnant.
Objection. I'm going beyond the order. The order was entered in October of 2002. If we're going to go back to the dawn of time, we're going to be here a lot longer than 2 hours.
I have 2 statements, short and quick.
Mr. Getz, you can't be talking about what happened before you all met.
I'm talking about, in relation to my daughter, the things that have happened.
Listen to me.
Sorry?
Listen to me. We have rules now.
Right.
From the date of the last order, okay, which was October 2002, anything prior to that was presumably covered by that order. So anything you want to say to change the custody or to modify another order has to go from the date of that order up to now. Okay, anything before that presumably was covered in that order, and you're not allowed to go back over that.
My actions since that time are based on these 2 statements I have to make.
You can't talk about anything that happened before October of 2002.
Yes, sir, I understand that. I'm saying what I'm doing right now is mine.
Don't do that. Now remember, anything you testify to, and this is another, just get you to, so you won't get frustrated with objections, because they're going to come.
Right.
It has to be things, you can't say anything somebody else told you.
No,
It has to be something you saw. Okay, you got that?
Yes, sir.
Okay. All right, you may proceed.
difficult to answer under these conditions and this important
These
information.
are conditions which every courtroom in the country is under, so.
I'm here today because Terry Strickland tried to kill our child and abandon it.
Objection.
That is important.
This
Objection.
happened before 2002,
When she was
October.
pregnant and after our child was born, when we were coming here, that's why we came here. Because I couldn't lose my daughter and I was afraid she was going to kill her.
This is before 2002 order?
When we came here at that time, I don't have the exact date, but when we came here, it was about that. That's what I'm trying to explain. I'm not here to try to make problems. I was worried absolutely about the safety of my daughter. And her family has a history of sexual abuse.
Objection.
That is since. That is not before.
My objection was based on prior to the October 02 order. He said they moved here together. They have not reconciled since October of 02, so that by definition would have to precede that.
Mr. Gibbs, you have to talk about what happened after 2002.
Since we arrived here, shortly after arriving here, being invited here, I came.
Objection. Again, the order was entered in October of 2002. He's talking about shortly after they arrived, which would have preceded that order.
When
In
did you
2002,
come here?
2002, June 2002. Shortly after that, when all this paperwork is here, referring to that time, shortly after that, she comes home one day, says she doesn't love me. She's taken her child and put me out on the street.
Objection.
This is during this time period, 2002.
No rule, I'll set it for background.
I'm just trying to explain why I'm feeling like I am and why I feel like I have to step forward and do something.
That was 7 years ago.
And during that time, after she came home and told me that she didn't love me and that I had to get out on the street and she was taking our child, that while I lived on the street, she made it almost impossible to be able to allow me to see my daughter for the last 7 years. I've had to go through quite a bit, including many occasions, riding a bicycle 3 hours round trip to spend an hour with my daughter. My daughter has not, on the average, been allowed to come to my house except for a few occasions, exceptions like maybe Christmas once or twice. My daughter is not allowed to be able to come to my shop, Mike's PC shop, where up until the time we got here, she used to work with me as a baby. I believe that during this time, the actions of Ms.
You
Strickland.
say you have a business?
Yes, sir.
What type of business is that?
Mike's PC shop in Farmville. It's a computer shop.
What?
PC.
Oh, PCs.
Yes, sir.
Computer.
Yes, sir. During the 7 years, I believe that her actions have not been conducive with a good mother. She has destroyed her family. She has made it nearly impossible for her daughter to see her dad. She has kept me from being able to make any decent decisions in my daughter's life. I have not had any opportunity to have say in her life. For instance, she is on medication right now for ADD. I'm not a fan of that, being a substitute school teacher also. I see what kids go through that are on those medications. In the discovery process leading up to today, there were a number of just flat-out wrong things. And I think it's very important to get the facts straight. The fact is, if I may, or to go through these discovery, sir?
You can certainly go through something else objected to, and then we'll talk about it.
Right. In the interrogatories, I made an attempt to try to get as much as possible as I could, agreed upon before we got here. There are things that, in my mind, shows a consistent pattern of deception. They're not being honest. They're not being straight. It is my opinion.
Objection.
And I have facts for that. There are a number of things. Like, I wasn't there when my child was born. Didn't cut her umbilical cord. I got videotaped evidence of that. That I wasn't jumped by Mr. Strickland and his son. I got videotaped evidence of that. These are plainly wrong. And I want to make the fact, these people are not being honest. Ever since I got here, they have twisted and turned and done everything possible to try to keep me away from my daughter. No decent person would keep a good man from being a child's father. Your position is indefensible.
All I talked to me, not to them.
These are just two of the things in the discovery that are plainly wrong, and I'm willing to submit evidence unless they concede.
About what?
That I wasn't jumped, I wasn't beaten and put out on the street, that I wasn't there and cut the umbilical cord and the first thing my daughter saw, that I wasn't the primary care provider of my daughter all the way up to the moment that we arrived here and they took her from me and put me on the street.
Yes, please listen to me. I'm trying to listen to you, but you're getting off on things that happened when the child was born. We're talking about a modification of a custody order, wanting to change whatever agreement is between the two of you right now. That's what you need to focus on.
Sir, I completely understand your point, but the fact is, at this moment, Miss Strickland's actions are not conducive with a good mother. At this moment.
Talk
not
about this moment. You're
yes,
exactly
sir.
right. Talk
yes,
about
sir.
now.
Yes, sir. I am not allowed to see my daughter except for 3 one-hour visits a week. I am not allowed to make
How
any
many hour visits a week?
According to your court action, I was put on the street and given 3 one-hour visitations a week. I had originally asked for Saturday, Sunday, and Wednesday, but you gave me Saturday, Sunday, and Thursday. During this time, up to now, I have not been allowed to be a part of my daughter, her life. I haven't been able to be a father to my daughter, and those are through Miss Strickland's actions. I have tried everything to get along. It's not happening. I have to step forward and say something, and these other things are part of background. It's important that people realize I'm not here just mad. I'm very concerned about my daughter, and I have major problems with what's been going on ever since my daughter was born. So I would like to know, are we going to be able to agree on some of the facts, or should I present evidence to the fact of repeated bad decisions by Ms. Strickland up to this moment about my daughter?
Apparently, you are past the stage of agreement, so yes, you're going to have to present evidence.
All right, well, I'd like to just confirm a few things here. According to my interrogatories that I got back from Ms. Strickland, her attorney, I have videotape on my computer that I would like to play.
Well, what?
Being jumped by Mr. Strickland and his son, about being with my daughter at birth and being the first thing she saw and cutting her bill, the things that they are plainly lying about.
Objection to the characterization.
The facts are not accurate, and you know that.
Mr. Gibbs, please listen to me. You remember it's a 2002 order, right?
Sir?
We have a 2002 order.
Right.
That was entered after the child was born.
Yes, sir.
Correct?
Yes, sir.
So the umbilical cord tape would be totally irrelevant, right?
It established
Do you
a fact.
understand that?
I understand your point, but establish the fact they're not being honest.
Do you understand why you're here?
Yes, sir. I'm trying to make sure my daughter's okay.
You're asking for a change in the custodial situation, correct?
Yes, sir.
What relevance does whether you cut the umbilical cord of this child have to do as to whether or not there should be a change of custody?
I was the primary care provider to my daughter. I was the one with her every day, taking care of her all the time from the moment she was born. It should be allowed to continue, and it should cause merit whenever you ask who should be taking care of the child. And that there is a repeated pattern of lies in their responses.
Why don't you tell me why you think she's a bad mother and not start before 2002 and start...
In 2002, yes, sir. In 2002, I was jumped and put out in the street and had my daughter taken from me. I lived on the street for 7 years.
Tell me, after 2002, what has changed to want me to change this order that was put in effect in 2002? That's what you should be doing.
Yes, sir. In the last 7 years, my ex has kept my daughter, I believe, from me, except for the court-ordered visitation. She has repeatedly made decisions that are not conducive to a good mother. My daughter...
Tell me how.
Well, taking her father from her is probably a big deal. In fact, it's the biggest deal to me. Unbelievable. After inviting me here and then putting me on the street to die. And then keeping my daughter from me. It's not even a good person, much less a good mother. How can I stand here and not say nothing? And That is the crux of my argument, that it is a repeated pattern of bad decisions that destroyed my family that goes on today that will not change unless I step forward and do something about it. And that's why I'm here.
Do you think the custody ought to change to you, or it should be modified to give you more visitation, or what?
I need to be in charge of my daughter. I am Mr. Getz. My daughter is Stephanie Getz. We are a family. She has two brothers, Michael Getz and Justin Getz. We are a family. Ms. Strickland was supposed to be in our family and chose not to. I believe that that decision was probably a mistake. To keep us apart like this, destroy us after inviting me here.
Where's the other children?
They're back west with their mother. I'm divorced. I'm fighting for custody of them too.
Okay, so you got two children that are elsewhere.
Yes, sir. My oldest son is 27. I mean,
So you got two children elsewhere, and then this child here.
yes, sir. And so I'm asking for legal custody of my daughter. The physical arrangements of her living where she is now, I totally understand. I don't want to rip her out of that. I mean, even though I don't feel comfortable with her being there, in my opinion, having a history of sexual abuse and me not being able to protect her or being around her is a mistake. But I'm willing to negotiate where she actually lives. But what I need and what my daughter needs is for me to be in control of her life, not shared custody, because it's constant conflict and it'll tear my daughter apart. I'd rather let go. So I come here today to ask for legal custody of my daughter, and I'm willing to negotiate physical custody of my daughter, although I would like to ask the court's clarification that if I am given legal custody, I may ask if I can take my daughter and the Getz family and go back to Texas. But right now, I'm only asking for legal custody to ensure the safety and health of my daughter. After a long, prolonged, documented pattern of bad decisions and conflict between me and her mother.
You know, you keep talking about these documented long history between the two of you. Tell me something about that.
Well, the videotape of me being jumped and put out in the street when I got here. The 7 years of having to go through unbelievable pain and suffering, riding a bicycle back and forth from Farmville to Greenville because they refused to even bring her to my shop or Farmville at all, knowing that I had to ride 3.5, 4 hours round trip on a bicycle to spend an hour with my daughter at Burger King or McDonald's. Since that time, I haven't contacted Ms. Strickland in any way since we've been here. To the best of my ability, I stay out of her way. I don't bother their family in any way. So our agreements between us, our actions between us have been very limited. But taking away her father, putting me through this, keeping me from her, with a history of problems and the things they have, and me not being able to be there and know where my daughter is, or I can't even call my daughter. She can't even call me, although they keep saying that she can. That's not true.
Are you saying that they haven't followed the terms of the October order?
The October order is what has limited us to this point. And they have violated by not showing up, not providing my daughter on numerous occasions according to the order. But to the larger degree, I'm not saying they violate that court order. I'm saying that we shouldn't have had it. We shouldn't have been to this point. Ms. Strickland never should have forced this issue and never should have asked the court for that order. That is not a good mother, as much as it pains me.
All right, anything else?
I brought with me today an individual that I've known since I was on the street first here when I saw you last. And I was going to ask him to verify or at least give another opinion of the things that have gone on. Not being an attorney, I'm not really sure of the procedure in this case, but I don't want to take up the court's time. Everything I'm saying is absolutely truthful. I'm willing to back it up, but I do not want to have to. I don't want to have to talk bad about the mother of my child, but this is unholy.
Well, what is it that you want me to hear that says the order should be changed or expanded, or in this case, you're asking that it should be just turned over on its side and the custody go to you? What is the substantial change in circumstances? that has taken place between 2002 and today that require the order to be overturned? Essentially overturned.
Yes, sir.
You're asking.
Since that time, I've been able to get back on my feet. I'm a substitute school teacher. I'm a coach at the high school. I have a business. I have a home. Although business is slow right now, it stresses me a little bit with the economy. And I do want a family to help take care of my daughter, not just me or Miss Strickland. But the fact is, I am capable and willing and able to take care of my daughter. And in light of all these concerns, I believe that it's necessary for the health and safety of Stephanie.
Where are you a substitute teacher?
Pitt County Schools, mostly in Farmville High School, and I coach there.
What do you coach?
Football.
JV, varsity, or?
Both. Just about everything. And put them on the internet, which is kind of historic. And I've got letters from other people in the community, from coaches to teachers to business owners to customers of mine to neighbors that know me, that know I'm a good man, that I'm doing everything I can to be in my daughter's life, that I should be allowed to have my daughter. And I'm willing, I got those, I'll present those. Overall, I am capable and willing to take care of my daughter now. And I do want Miss Strickland and her family to be a part of that.
Tell me about where you live.
I have a small 2-bedroom house in Farmville, 6202 Turnage. I've had a room set up for my daughter for 6 years. And my shop is right there in town, like a half mile from there. As a substitute school teacher, my daughter can be in school with me. I can keep an eye on her and know where she's at all times, which stresses me since I've been here. As a father, I should know where she's at, who she's with at all times. She should be able to call me or come to me at any time she needs. That would allow this.
Well, how often do you communicate with her by phone?
My daughter? I am not allowed to call my daughter or anyone except for 1 hour before our visitation. I call Mr. Strickland to agree to meet in public somewhere for an hour. So I don't ever get to communicate with my daughter, although they keep saying that I can. I don't know. It ain't happening. I bought my daughter a phone. Somehow that's disappeared. So I've had almost no contact outside the 3 one-hour visitations a week with my daughter. And I have newspaper articles that were written about me in Farmville. I have, again, letters of support from people in the community. You know, I'm a good man, and I can do this. I'm the father to Stephanie. I need to be able to do what I need to do as her father. This custody order must be modified to allow me sole legal custody of my daughter. And then I would be happy to negotiate the physical custody, and I'm not interested in trying to remove her family or keep her from her mother or grandparents. I'm trying to keep my family together. Until this time, I've been cut out of the family. And I don't believe that it will change unless I'm the one in control of my daughter's life.
All right, anything else you want to say on direct? You certainly have a chance to offer your witness in that, but anything else?
I would like to call David Strickland as a witness.
I'll certainly let you do that, but you cross-examination, you have to listen to his questions first, okay? All right.
Good morning, Mr. Getz.
Good morning.
Mr. Getz, I'm a little confused. You said that you were homeless for 7 years, and then you said that you've been living at your present address for 5.5. Which is it?
Both.
Okay.
I was homeless 7 years ago, and I had fought to get back off the street, and I finally got a place to live. It did not allow me to be able to come back and fight for my daughter because I didn't have enough money. I was barely surviving. It wasn't until this last year that my business did well enough to where I felt like I could fight for my daughter and take care of her.
Okay. So you've been living in this house for 5.5 years?
Yes, sir.
So how long have you had a car?
I have it ever since the first 2 or 3 years when I was living on the street, had a place to live, didn't really have one. When I came here, my truck was broke down. I've had It's a hard answer because I've had broken down vehicles back and forth over the last 7 years, and I've had to ride a bike most of the time.
Okay, so your testimony is more than half the time over the last 7 years, you've been limited to riding a bicycle for transportation. Is that your
I
testimony?
would say over the first 5 years, in the last 2 years or so, I have a vehicle and it's not a problem.
Okay. And until a child support complaint was filed by the 4D people, you weren't providing any financial support for the daughter you profess to love so much.
No, that's
Isn't
not
that
true.
correct?
That is not true.
Well, you paid a grand total of $520 until sometime in 2008 when that child support petition was
And I
filed.
bet you...
If you'd answer my question.
Yes, sir.
Okay.
I did. But that was about 80% of my total income. Living on the street, barely surviving. I gave everything I could possibly give.
Well, Mr. Gatz, you just said that you have lived in your present home for 5.5 years. How much is the rent?
$250.
Okay, $250.
Plus utilities.
So 6 years, $520 total. That's about $100 a year. Divided by 12 months per year is what? $8 a month.
Basically, as a substitute school teacher, making $57 a day, and half of that going back to Texas for child support for my son back there, that left me with barely enough to live.
Okay.
And I still gave it to my daughter. And more importantly, I met her 3 times a week, every opportunity I could to be in her life.
And in fact, the son you talked about a little while ago, you hadn't seen him in over 10 years, have you?
I am fighting for custody.
If you'd answer my question, you hadn't seen him in over 10 years, have
I
you?
talk to him on the phone regularly.
And in fact, you owe thousands of dollars to his mother in child support, don't you?
I found out about it when I got here and started teaching. I had no idea until I got here that there was even an order for child support.
Okay. And the other child that you talked about custody, he's 27 years old. There wouldn't be any custody issue there, would there?
Sir, he is in prison, and I am trying to get them to release him to me.
Okay. Now, Mr. Getz, Mr. Strickland, Sherry's father, pursuant to that October 2002 order, has been the party who was facilitating your visitation with your daughter. Isn't that correct?
Except for the times that he didn't show up.
Isn't that correct?
Most of the time, yes.
Okay. And how many contempt motions did you file with this court alleging that Mr. Strickland, or I guess Sherry Strickland, was not complying with the order? How many?
I was unable. I had 0, but I have
0.
evidence recorded conversations when they did not
Okay.
show up.
Sir, I didn't ask that. Okay. It's a fair statement, a true statement, that the overwhelming majority, in fact, you can count on one hand in 7 years the number of times that you didn't get visitation with your daughter.
Roughly, yes.
Okay. 3 times a week times 52 weeks a year, that's 156 visitations
But I wrote a
times 7 years. That's almost 1,000 visitations, and on one hand are the number that you didn't get to exercise.
It's
Right.
still a violation of the order.
Okay. And in fact, when you opened your PC shop, Mr. Strickland brought Stephanie over to be present, didn't he?
For the opening.
Right. And that was your request,
Yes,
wasn't it?
absolutely correct.
And he accommodated you on that, didn't he?
Right.
Sir?
Yes, sir.
Okay. And another time, he brought Stephanie by because you wanted Stephanie to see where you were living. Isn't that right?
It was at Christmas, I think.
Mr. Strickland brought the child by and allowed her to go inside your home to see where you lived. Isn't that correct?
Yes.
Okay. And that wasn't required by the order, was it?
It was a violation of the order.
Sir, it wasn't required by the order that he do that, right?
It was a violation of the order.
Okay, so Mr. Strickland violated the order by accommodating your request that Stephanie be allowed to go by your house and see where you live. Is that what you're saying?
They violated the order at their discretion. Whenever it wasn't in their benefit, they did not.
Okay, sir, they violated the order in your favor, didn't they?
On occasion, other times in theirs, most of the time in theirs.
Okay, so you take issue with the fact that at your request, the Stricklands went outside the order to give you more than what the order required.
I take issue with the fact that when it's in their benefit, they violated it, and when it was to mine or my daughter's benefit, they refused to.
You've been made aware of school functions and church activities and other special occasions, and you've actually been in attendance for some of those, haven't you?
a small percentage of my daughter's life, or maybe 1% of her life, I've been allowed to be a part of.
And Mr. Guest, tell me how many times you've been out to your daughter's school to talk with her teachers about how she's doing.
As often as I'm allowed.
Okay, and that's zero. Would that be fair to say?
Right.
Is there an order that prohibits you from being able to go out and talk with the teachers?
Yes, the current custody order says that I cannot.
It
I cannot
prohibits.
be anywhere near my daughter. I guess technically that's not right. I have a custody order where I am, according to Judge Blake, forced to be able to meet with my daughter in a public location for 1 hour 3 times a week. And I've been doing that without fail, except at the times when they miss. And outside that, I'm not allowed, I'm not supposed to be able to contact them, so I try to stay away.
Mr. Getz, you're referring to the Domestic Violence Protective Order that was issued initially, which was in effect for a year and then renewed for an additional year. Isn't that correct? Yes or no?
No.
Okay, so
That was thrown out.
Okay. The Domestic Violence Protective Order that Judge Blick entered, you're saying was thrown out of court.
The circumstances that brought that upon was thrown out. I did nothing wrong.
Okay. Are you disagreeing with the fact that a DVPO was entered against you after a full opportunity to be heard by Judge Blick? Is that what you're saying?
It was entered in, and based on the evidence, I understand why Judge Blick did so, but I did absolutely nothing wrong. And before it went to trial, it was thrown out because it was baseless. And since that time, she has even renewed it another year after that, and I haven't even talked to her.
Mr. Getz, how do you renew an order that was thrown out?
I don't know, sir. I was at my dead mother's funeral when you guys went to trial behind my back and did it. In Texas.
Sir, that wasn't my question. My question was, how does an order that's thrown out get renewed?
The charges that it was based on were thrown out. But it went on for 2 years based on y'all behind my back when my mother was dead.
Mr. Getz, I want you to show me in the existing custody order where it says you are prohibited from making contact with your daughter's school. Can you show me where it is?
Sir, why don't you answer me? What is the current
Sir,
Mr. Getz, you can't ask any questions going in.
I'm trying to clarify.
You can certainly clarify anything you wish to that he doesn't ask you about on redirect.
Could you please clarify?
Can you show me in the custody order that was entered on October 14, 2002, where it says you don't have the ability or the authority to go by and talk with your daughter's teachers?
It's not in there.
Okay. And sir, notwithstanding the fact that you have the authority and the ability to do that, you didn't do so, did you?
That's not true.
Okay, well, tell us when you went out there, Mr. Getz.
Sorry?
Tell us when you've been out to your daughter's school to talk with her teachers.
According to...
No. Answer my question. Tell me
I have, during the 7 years, done everything I could do, and I was not allowed to be able to do that. So, except for, I think, 1 or 2 occasions, where they made an exception, which I guess is a violation of Judge Blick's order, I was allowed to do that.
So my question again is, tell me why you didn't go out to your daughter's school and talk with
Because
her
Judge
teachers.
Blake told me I couldn't.
Okay, and that's in a DVPO that, according to your testimony, was thrown out but then renewed for a couple of years. Is that right?
The reason the DDPO was put into effect was based on actions that did not happen. And so after those were thrown out, the DDPO continued, even though there was no justification for it. And after the first year, when my mother died and I was back in Texas, y'all went behind my back and didn't even tell me and had a renewal for another year when I hadn't even so much as talked to anybody. There was no grounds for that DDPO.
Sir, there's not been a DVPO in effect since sometime in 2004.
Right, 2 years, as I said.
Okay, so between 2004 and today, which is almost 5 years, the number of times that you've been out to see your daughter's teachers to figure out how she's doing in school is 0. Is that right?
No, like I said, once or twice in exceptions, they allowed me to do so. I was following what I thought was the rules of our arrangements. And that is that I only see my daughter 3 times a week. I call an hour before, and we make an arrangement in a place, and I go there. That's what I've done, exactly what I was told to do.
And in fact, during the time that you were out, quote unquote, on the street, Mr. Strickland, Sherry's father, actually brought you insulin, didn't he? Because you couldn't afford it.
When I was in the homeless shelter, he brought me insulin. I don't know if that's a great thing or a bad thing. I don't know what to say.
He brought you insulin.
I was a guy, yeah, that was kind of
Right.
since they put me there.
And in fact, you were allowed to come back to the home for about 10 days prior to the DVPO hearing. Isn't that correct?
Because I won in court and I was allowed to go back in my home for 10 days before y'all put me back out again.
Mr. Getz, you're aware that Stephanie attends the Elm Grove Church?
Yes, sir.
Have you been there?
Yes, sir.
Okay. On what occasion did you go to Stephanie's church?
It's a public place. I've been there a number of times since I've moved here.
That's the church that the Stricklands attend, isn't that correct?
Right.
Okay. Do you have your own church that you attend?
That one primarily, I guess. One or two others I go to sometimes.
Okay, what are the one or two others, Mr. Getz?
The one in Ayden, Knowing One's Ministry, in Farmville, two places that I
Okay, tell me the names.
Methodist Church.
What's the name?
Farmville United Methodist Church.
Okay.
And the other one is just an odd name. I can't remember. I was trying to remember the other day. It's downtown Farmville. They got a youth group. I work with them sometimes and the kids. I'm a substitute school teacher.
Okay. And Mr. Strickland, you have no family other than Stephanie here in Pitt County, isn't that correct?
Right.
Okay, and Sherry has a pretty large extended family here, doesn't she?
Which is why I brought my daughter in. So
Okay.
she would have family.
Okay. And in fact, you're aware that Stephanie spends a lot of time with her extended family.
Absolutely.
Okay. She seems to enjoy it, doesn't she?
Yes. Which I don't want to change.
And you testified about an alleged assault between yourself and Mr. Strickland. That's Mr. Strickland sitting back there, isn't it?
Yes, sir.
That's when you came to his house with a video camera and demanded to know where your daughter was. Isn't that right?
I asked for my daughter was
You demanded to know. Mr. Strickland asked you to stop filming them, didn't
He jumped me before he said
he?
anything.
He asked you to stop filming them, didn't he?
No.
Mr. Strickland, yes, you make a habit of taking video cameras to places and sticking cameras in people's faces and antagonizing them. Is that what you do?
When I feel like they're lying to me and I need to document the truth and protect my daughter, yes.
Okay. And you're trying to protect your daughter on that day because she wasn't where you thought she was. Is that right?
No. Because her mother had just come home and told me she didn't love me, she was taking the child and was going to kick me down the street. I told her, please go get your Stephanie, because Stephanie wasn't there, and Mr. Strickland, and we would all sit down and talk about what's best for my daughter. Obviously, Ms. Strickland and I, Sherry Strickland and I were not going to be together. We had to make some arrangements that were good for my daughter. She left and never came back. I waited for like an hour. I didn't know what was going on. Then I realized these people are not being straight with me. They're setting me up. And I started recording the camera, and I documented it.
Mr. Getz, you've got a bedroom for Stephanie in your home?
Yes,
Is there a bed in it?
yes,
You sure about that?
don't lie.
How long has there been a bed in her room?
I set that room up 5.5 years ago when I went to the house.
Okay. And in addition to not filing a contempt motion in the last 5 or 6 years that you've had a stable residence, you've also not petitioned the court to modify the order, have you?
Because I knew that by myself I could not take care of her. And I had to be able to be on my feet with a decent business, with a good income, and knowing that I didn't believe their support if I had my daughter. I had to wait. I couldn't just jump in the fight and try to fight for my daughter. I had to make sure I could take care of her.
Okay, so it's your testimony then, the very instant when you realized you had the ability financially and otherwise to take care of your daughter, that's when you filed a motion to modify the order. Is that right?
It's not a moment's decision, but over like a month or 2 or 3 when I started gathering my own attorney and trying to get this together, yeah.
Okay, so then by your own testimony until the date of the filing of the motion to modify the custody order, you yourself didn't believe that you had the ability to be the primary caregiver for your daughter and to have her in your home. Isn't that correct?
No.
Well, tell me where I'm wrong about that, Mr.
I believe that I could, but it's not in her best interest not to have family. So I wasn't going to rip my daughter away from them and keep her to myself. That wasn't good policy.
Well, tell this court when you believe that you have the ability and the financial capability and otherwise to be the primary caregiver for your daughter and to have her live with you in your home. Tell me when that was.
It has not happened. I do not believe that I can take good care of her without a family. And that is what I've been trying my best to do. And so the only reason this all started is because she sued me for child support. And so I had to defend myself, and I said to him, no, I'm not a deadbeat dad. I'm trying to take care of my daughter.
So did you just say the reason you filed a motion to modify this custody was because Ms. Strickland sued you for child support? Did I hear that right?
The child support court hearings is what I guess initiated most of this, that I was able then, at that point, realize that they are not going to be family for me and my daughter, and that I have to step forward and make some decisions, and I did so.
So, because Ms. Strickland sought from Stephanie's father financial support, you believe that Ms. Strickland...
No. That it is clear at that point that she was never going to reconcile and be a family, that she only expected to be paid for destroying her family.
Okay, so you're saying that it took Ms. Strickland filing a child support complaint to make you realize she wasn't going to reconcile with you? Is that what
I
you're
was
saying?
trying at all efforts to try to resolve this without going to court like we are now. And at that point is when I decided this ain't never going to change. I have to do this. And I was able, and I did so.
Okay, so you're saying that sitting here today that you were capable, financially and otherwise, to be Stephanie's primary caregiver. Is that your testimony?
Well, except for the bad economy, yeah. But
No. Is that your testimony?
I am concerned about being able to take care of my daughter, like any good father would be in a bad economy with no other family to help them. But yes, I can. I will.
You can and you will.
Yes.
All right.
Because it is best for her.
Now, just so I understand your position, are you saying you want your daughter to come live with you primarily and change schools and have to make new friends and move to Farmville? Is that what you're saying?
I believe that would be best for her, but I'm willing to negotiate that, not to uproot her from her current condition. The most important thing that I'm trying to establish is control of her life, and that I have some say about what's going on, and that I know where she's at, who she's with at all times, like a normal dad would.
You want some control.
I want all control. Normally it should be her mother and me, but she has not, in my mind, been able to make wise decisions, so I am forced to step up and do so. I have both the right and obligation as a father.
Okay, so your position under oath is that you want complete control over your daughter. Sole legal custody, right?
I want us to be a family is what I want, is why I came here. But being that they have not acted in a manner that I think is wise, I am forced to this position for the benefit of my daughter.
Okay. And in fact, Mr. Gaspis, Ms. Strickland has offered to allow you to have some overnights with the minor child and spend weekends with her and some time in the summer and so forth, hasn't she?
Not that we can report. There was no effort before that.
Okay. But the point is that that's not what you want. You want complete control over your daughter, right?
The most important thing is that I know that she's okay, that I can know where she's at all times, that she can call or come to me if she needs to, and that is what is being kept from me. That's what I'm fighting for. Where she physically lives is not, that is negotiable. I mean, I realize that she's got roots now, and I don't want to take her away from her mom, or I'm not trying to do anything like that. But I have to establish control in her life.
Okay. All right. Those are my questions. Thank you.
All right. Based on those questions, Mr. Getz, is there anything you wish to add or answer in response to the questions they asked?
No, sir.
All right, you may step in. All right, Mr. Getz, do you wish to offer any evidence? Any other evidence? All right.
I'd like to call David A. Martin.
All right, if you'll come around, please. If you'll put your left hand on the Bible and raise your right, please. Yes. All right, if you'll have a seat. First of all, before Mr. Getz begins asking questions, will you state your name, please?
David A. Hart.
Hart?
A. Hart. A. Hart.
A. Hart. How do you spell that?
A-H-A-R-T.
Okay. And where do you live?
I live in Greenville
How long have you lived in Pitkin?
since 1989.
Okay. All right. Mr. sketch, you may ask him questions. You don't have to stand up.
Mr. Ahart, how long have we known each other approximately?
Since somewhere around 2002.
How did we meet?
A police officer from ECU introduced you to me when you were on the streets.
Right. And what were the circumstances at that time that you understood about me and my life?
You were homeless. You just had to split up with your wife.
We're never married.
Okay, I apologize. To your, I guess it was fiance at the time.
Right. And over the last 7 years, do you believe I've been a good father and tried to make attempts to see my daughter and everything I could to be in her life?
Concerning you as you being a father, it's been courageous as far as the attempts you've made to spend time with her, and I mean, numerous times, just the bicycle in the rain and stuff. I mean, every week I was just amazed.
And do you remember on occasion when there was sleet and night, and I had to ride 3 hours on the road, spend an hour with my daughter at McDonald's, and you, at that time, were trying to help me out and give me a ride? Is that true?
That's true.
And during this time, have I ever done anything live or anything that you know of that as a character witness?
As a character witness, I have never known you tell a lie. To always be very honest, no matter what the cost.
Absolutely. That's all my questions, sir.
All right, any cross-exam?
I have no questions.
All right, you may step down. Thank you.
I have other evidence.
All right, what other evidence you wish to offer?
I presented a DVD CD-ROM to council and listed that to the court. Basically, I have the things to back up everything I've been talking about. Everything from newspaper articles and as to my character and my position in Farmville, as to having a place to live, coaching, a good man in that town. Pictures with my daughter and stuff from birds from now. The videotape conversations with Mr. Strickland when they refused to bring her to me. And I kept saying, you're in violation of the court order, and they would not comply. Pictures and videotape when my daughter was born, as I guess I cannot present. And numerous letters from and support from individuals within my community that believe that I should have my daughter. I have them here. I can show you if you like.
Do you have those in paper form, these letters of recommendation?
Yes, sir. I've already given it to the court and the council.
Have you seen those?
I've seen them, yes. And I would like to be heard on each request.
All right.
Well, there are 11 what he calls items of evidence. The first one is the videotape of the birth of the minor child. We would object to that coming in. First year baby highlight video, same objection that precedes the order. Number 3 are photographs which appear to predate the date of the order as well. Number 3, we object to that. Number 4, Daddy and Stephanie, looks like sometime in 07. We don't have an issue with that. What Mr. Getz calls the, quote, Strickland assault video, certainly Mr. Getz can introduce that if he wants to. We certainly disagree with the characterization of it. Number 6, the, quote, Sherry assault picture. Again, we disagree with the characterization that precedes the date of the order. If we need to get into that, then we'll spend a lot of time. We just oppose that. Number 7 and 8 are videos of Mr. Getz filming himself talking to Mr. Strickland on the telephone regarding some visitation issues. I think the second one, in June of 2008, was that he wanted Mr. Strickland to bring the child to see him on Father's Day rather than meet Mr. Strickland somewhere else as required by the order, but we don't object to that. The ribbon cutting webcast number 9, we don't have an issue with that. Number 10, the newspaper article, that's fine. Number 11, letters of support, we do oppose that coming in just because I had no opportunity to cross-examine letters of support.
All right. Exhibits 1 through 3, the court sustained his objections. For number 4, the pictures, I'd like to see those, Mr. Getz. The number 5 is sustained, number 6 sustained, number 7. I'm not sure at this point any of the videos add or subtract anything to the case would be. I'll sustain those. Your newspaper article I'd like to see, and your letters I'll see. So any pictures, letters, or the newspaper article, but any of the videos I think at this point would not be, although relevant, would lead, what's that, Rule
403, unfairly prejudicial.
Anyway, let me see those pictures that you have, and do you have those with you?
Yes, sir.
Let me see those pictures and the newspaper article and the any letters that you have that you want the court to see, okay?
Yes, sir.
Do you have those in printed form?
I have it here on my computer where I can display it, and I believe it's submitted into the court and to the council on these.
And Your Honor, we had this issue with Judge Hilgren previously, and we discussed how to present this stuff into evidence, and I think it was made clear to Mr. Guest at the time while he could submit things in CD form that he needed to have print copies to hand out and introduce into evidence and make part of the record. At that time, he's done that.
No, that's not what I understood. I understood that I could present it that way to you on CD.
Excluded irrelevant evidence under Rule 403. Wasted the time computing the issues. You have the you have a copy of the CD-ROM with you?
Yes, sir.
All right.
And I can show you right here on the slide of the piece of paper.
The problem you're going to have, and you may be more computer oriented than I am, it took me a little while to figure out how to cursor from item to item. Of course, the problem is by the time you cursor from item 1, which you're not supposed to see, to item 2, you've already seen part of item 1. And I would just think that CDs would be something that really would not be appropriate to introduce into evidence.
Do you have the CD-ROM with you?
Yes, sir. Sir, I can bring up the pictures if you want, one at a time. That's all you'll see. This is what you want to see, just like I was told with these papers.
All right, here's the pictures.
All right, sir. Is there one particularly that you're asking for?
The pictures that you want to show that would have been exhibit number 4.
Sorry?
The pictures, the exhibit 4 pictures, I think those are your daughter, I believe.
There's numerous ones, so I'm not sure.
Any of those pictures.
All right. This is me and my daughter.
You can put it right there, up and down.
I can bring it over there. This photo was taken. This photo was taken, my daughter and I, during one of our visitations here in Greenville. And I believe it shows how close we still are, and that's everything we've been through and stuff. I don't believe there would be any problems at all with her being with me. I don't want to take away from her mom, but I'm obviously, my daughter and I are very close and still are. What's wrong with questions? Well, I wanted to play the Strickland song in my grand opening. Well, the grants open, here's, of course, my family photo when I was there when she was born, better support. And I also have, of course, the letters, but here is the newspaper article about my work with the high school and my position in the community. Yes, sir. That's one of the good things about story. The only other picture that was in there was down there, which was my daughter, just a few years old. I just taken her having shots. She has a little man baby on the way.
You said you had some check photos?
Yes, sir. They're on the computer, of course.
You have those in your print?
Yes, I was submitted to the board and council.
They're on the CDs and
Okay.
Here are the, if you like to read them again. This letter is from the head football coach that I've been working with now for a number of years, just our formal supplies. This is a business owner in Cornwall that is also a customer of mine that I've known. She's one of the first customers I had when I started working in Cornwall with computers as a substitute teacher on the side for my shop. But, This is an individual customer of mine, and also lives in Farmville and works for the 800 fire company. All right. This one is Miss Sauls is a school teacher in Cornwall that I taught with. And this one is handwritten, and I don't know if you can read it that well on the computer, but that's from Coach Sauls, the former head coach of Farmville Central that I coached with before I coached with. No, so those are a few of the people supported that I have in this case.
Okay. All right. Any further evidence at this point?
I'm not allowed to play the grand opening of my business. I'm trying to establish that I got business and work and what it looks like.
Well, I mean, from reading those letters, I can take that. I don't think it would,
Okay.
I think it'd be a, accumulation of evidence that I've already.
Well, I would present more evidence needed.
That's fine. All right, anything else?
No, sir.
All right, anything for your side?
Yes, sir. What is the time at this point that I have left?
Let's see, you have, you used 20 minutes, so you have, 40 minutes.
Okay. Sherry Strickland is my first witness. She
All right.
brought up and be sworn.
Let me,
So instead of technology, that's what it's for, to show the truth, the truth, nothing
State, thank you. State your name, please.
Sherry Lynn Strickland,
And Ms. Strickland, what kind of work do you do?
registered nurse.
And how long have you been a registered nurse?
Registered nurse a little over a year, LPN for 15 years before that.
Okay. And you and Mr. Getz have a daughter together, is that right?
Yes, sir.
And what is her name?
Stephanie Ann Getz.
And how old is Stephanie?
She's 9.
And where do you presently live?
We own our own home, 4830 Old NC 11, Ada, North Carolina.
And how long have you lived at that address?
6 years, plus 7 years.
I'm not going to ask that this be introduced in evidence, but I'm going to hand you a photograph. And hold that up and tell the court who this is, please.
This is my Stephanie. It was taken at the North Carolina Zoo. The trip and her and I took together.
Would you hold that up so the court can see?
Many needs.
What kind of child is Stephanie?
She's happy. She's healthy. She loves sports. She loves anything science, astronomy. We look at stars together with the telescope. She's got pets. She loves animals. She's an animal rescuer when she grows up.
And does Stephanie have extended family here in Pitt County?
Yes, sir.
Now, who are your extended family? Well, who is her extended family here?
My mom and dad, my name Agnes Strickland. She has great-grandparents on my mother's side. My great-grandmother turned 89, Kelly Nobles, last week. And my dad's side of the family, Strickland, Nobles, Chapels. My aunt Chapel, that Chapel, and her husband BT. Lots of cousins. Had a good life.
How many cousins does Stephanie have?
Well, truly, I have a sister who has one child, and this child's 21 in college now. So technically only one first cousin, but she's got a slew of second cousins, which, since they're young, Stephanie feels they're just like her second cousins.
And what's the age range for the second cousins?
9 weeks to 5 or 6.
How would you describe your family in terms of closeness?
Very close. Lots of family get-togethers. And
How often does your family get together?
once a week, at least.
Now, Stephanie is in what grade in school?
She'll be going to the 4th grade this year.
Okay, and where is she in school?
Aiden Elementary.
And prior to Aiden Elementary, where was Stephanie in school?
Since the age of 3 up until 3rd grade, she was in private school, Greenville Montessori School here in Greenville.
And how did Stephanie do with Greenville Montessori?
She seems to do well day to day, but Montessori does not have a grading system. So when they took the Iowa test in preparation, I guess, for the end of grade test or whatever, she did not do very well. So it was at that point I decided to put her someplace else.
Okay, and that would have been when?
Beginning of 3rd grade.
Okay. And now, as a result of realizing Stephanie wasn't doing well at the Montessori school, tell us what you did, please.
Well, I took her for a psychological evaluation. She was diagnosed with ADD. Really thought long and hard about what was the best interest of her to do. I didn't feel Montessori had the resources to help her. Public school normally has the resources to help. She was placed on medication, and I decided to enroll her in public school for the first time, starting in 3rd grade.
Okay. And was that at Aiden Elementary?
Yes, sir.
Okay. Now, first witness, Your Honor.
Okay.
Ms. Strickland, answer by mark plaintiff's exhibit number 1. Now, tell us what that is, please.
This is her 3rd grade report card.
Okay. And how did Stephanie do?
There's some B's.
And in language arts, the end of the year was 89.
Yes, sir.
Mathematics, end of the year 85. Social studies, end of the year 89. And science and health, end of the year 90. Is that right? Okay. And it looks like she got all S's for art, music, physical education, and handwriting. Is that right?
Yes, sir.
And for the most part, with the exception of one check minus, her social and work habits were in the check range. Is that right?
Yes, sir.
I will move to introduce plaintiff's exhibit 1 into evidence.
All right, any objection to the report card, Mr. Getz?
So how do you feel like Stephanie has done in the adjustment from the Montessori school to Aiden Elementary?
I think she has done very well. Greenville Montessori had a total of 90 children total from like kindergarten through 6th grade. She goes to a public school. So I'm anticipating this year to be even better. This was kind of a transition for her. She'd never seen so many people in her life.
Tell us what type of work Stephanie has, homework Stephanie has, and what types of things the two of you do together at home regarding homework and studying.
Her weakness seems to be mathematics. We spend a lot of time on mathematics. At home, we do her regular homework, and then we also do a little extra. I don't do too much because the teacher tells me it makes things worse, so we just do a little extra work. Her strength in reading, she loves to read. She always did very well in reading.
Can you give us an idea during the school year what a typical day for Stephanie is?
I took her to school every morning.
How far is Aiden Elementary from where you live?
Maybe 2 miles.
Okay, so you take her in the morning. Okay.
Drop her off, and then some days I was able to pick her up, and some days my parents would pick her up.
Okay.
Except on Wednesdays, she went to a kind of an after-school program at our church called Ultimate Wednesday. The church bus would pick her up on Wednesday and take her back to the church.
Okay, which church is that?
Elm Grove Church in Aiden.
Okay, is that the church that Stephanie attends as well?
Yes,
Okay. So is that every Wednesday?
yes, sir.
Okay, is that both during the school year and in the summer, or just?
Sorry, it's during the school year only, I'm sorry.
Okay. And then what time do you typically get home?
I typically, about 5 o'clock, 4 and 5.
Okay. And then what happens?
My parents have her at that time. Mom's probably already done her homework with her too. Mom helps her. And she'd be outside with Grandpa running around, and I pick her up and take her home, make supper, and make sure she's got everything done.
Do you all have a particular bedtime in your home?
We start at 7:30, 8 o'clock.
Okay. And what time does Stephanie actually go down at night?
By 9. Yes.
How far away do your parents live from you?
Less than a mile.
What kind of relationship does your daughter have with your parents?
She adores them.
Now, the home that you reside in, is that a single family residence?
Yes, sir.
I've got some photographs and I'll hand them up to you in just a minute. But if you would, just describe the home for us before you get into the photos.
It's a double wide trailer on an acre of land, which was purchased by my father as a gift for me and Stephanie. So we'd have a place to live, a stable home.
Does Stephanie have her own room?
She has her own room. She has her own playroom. She has a craft room. She has a little mini pool table and an entertainment room. The whole house is hers. We just have it.
And Stephanie, did she make any friends this year at Aiden Elementary?
Yes, she did.
Okay. Did you all have any of her friends over for any special occasions or sleepovers or anything like that?
For her 8th birthday, I had 13 8-year-old little girls at my house for her sleepover.
Are these children from Aiden Elementary?
And some from church also.
Okay. Does Stephanie have a best friend?
Yes, Vanessa King. Yeah.
And does Stephanie also, from time to time, spend time with her friend at a friend's house?
Yes.
Okay. Describe Stephanie's behavior as a child.
In what way?
I mean, is she an outgoing child?
Oh,
Is she introverted? Is she well behaved? Is she polite? That kind of thing.
Yeah, she is very well known. We can go to the grocery store and somebody will know her from church. Very outgoing. She always has a speaking part in the Christmas play because, first of all, she can memorize the lines and she's not afraid to go out there and do it. She's excited to do it.
Now, you and Mr. Getz have been following an order dating back to October 2002 for some period of time. Based on what your observations are, has Mr. Getz been permitted to visit with the child pursuant to that order the overwhelming majority of the time?
Absolutely. My father has gone above and beyond for the past 7 years what he should have had to do. A lot of times Michael's car broke and he was the one that could not make the visits. If for some reason we had to miss a few visits because we had to go to the beach or there was something going on, my father made very well sure that the visit was made up. In fact, just recently, 3 weeks ago, I was with my Aunt Pat, Chapel Beach, and her family at the beach, and we missed the weekend visit. And so, Stephanie spoke with her dad on the telephone. And then to make up that following Thursday, my dad took Michael and Stephanie to the beach for the whole day at the North Carolina Aquarium, Fort Macon, to make up for that. So you guys have a day at the beach.
So really, I mean, we're talking about every single weekend for 7 years?
Yes, every Thursday, Saturday, and Sunday. He just had to stop what he had to do.
What is your feeling, Ms. Strickland, on modifying the order?
At this point, my child is almost 10. She tells me she wants to go spend the weekends with her father. She's older. I have no problems with that. That's what she wants. I mean, that's natural. Okay.
Was there a time that you did have problems with sending your daughter to stay with her dad on the weekends and unsupervised and otherwise?
Yes, sir. When this all first happened, he had threatened to leave the state with my child, and she was not but 3 years old. I didn't think she was old enough to defend herself.
Overruled, Mr. Getz, that's one of the findings in the prior order, okay?
Yes, sir, it's based on no evidence, and I know
Well,
it's not true.
when the court makes it a finding of fact, it becomes the evidence, so, okay? So that was a concern to you. Did you have other concerns over the years regarding Mr. Getz?
His stability, just having, a place for her to stay, transportation, money, just anything. Although he was violent with me, he was not. I never saw that with Stephanie, so that wasn't a concern here. But
At this point, then, you feel as though Stephanie's old enough that she can let you know if there are any problems?
yeah, and she wants to go.
Okay. And in terms of your dad being in the middle of the visitation, the beginning and the end, how do you feel about that?
I think it's gone on long enough. I think I feel like there's been some problems where he's been badgered by Michael unnecessarily, and he's going above and beyond what he had to do. I don't think he should have to go through that anymore. And that's another big reason also this time.
Now, at some point, you and Mr. Getz discussed transitioning into an every other weekend and some overnights, didn't you?
Yes.
And Mr. Getz's position was he wanted sole legal custody,
He
right?
wanted full control over her. He wanted her off her medication. He wanted everything.
Do you feel like you and Mr. Getz would be able, as parents, to talk about those types of issues together and mutually make some decisions regarding your daughter?
We haven't really been able to agree on anything. I think if the communication was done, email or something like that, certainly have no problem.
Do you have an email account?
Yes, sir.
Okay, do you know if Mr. Getz has an email account?
Yes, sir.
Would that be your preferred mode of communication?
For now, like I said, you have to kind of ease into things. I'm open to things go well, maybe take it to the next level. But you got to crawl before you can run. And that's what I was trying to explain to him when I had offered this, you want full control. I'm like, well, wait a minute now, let's take it slowly. You didn't want to take it slowly. You wanted it all from us. I said, wait a minute. I'm all for you coming over Christmas morning when she's open Santa Claus gifts. I'm all for that. But you got to start slowly.
Over the years, have you gone above and beyond what the order required regarding Mr. Getz's visitation?
Yes, he has been to so many soccer games, church basketball games, taekwondo tournaments, he's been to so many things.
And you made him aware of?
Yes, Stephanie says, can Daddy go? And we'll say, yeah.
Okay. And with regard to Christmas and other special occasions, how have you all handled those over the years?
To the best of my recollection, we've seen her every Christmas and holiday. To the best of my recollection.
Oh, you certainly can cross-examine.
To the best of my recollection.
My first witness,
Anthony Marcus, plaintiff's exhibit number 2. And first of all, just tell us what the attack is. Are those photographs of your home, both the outside and inside?
Yes, sir.
And those photographs helping illustrating your testimony regarding where you and Stephanie live?
Yes, sir.
I move to introduce plaintiff's exhibit 2 of evidence.
All right. All right.
And if you would, just stand in to your honor.
You said that's fully paid for. The mortgage.
All right. Now, Ms. Strickland, in terms of, yes, your testimony was that you, at this point anyway, you would be fine with Stephanie spending some time with her dad. Would that be every other weekend?
Yes,
Okay. And sometime in the summer,
certainly.
and dividing up the holidays in some fair way. Is that right?
Yes, sir.
Okay. Now, in terms of the problems, some of the issues that you've had over the years with Mr. Getz, do you believe that you'll be able to place those to one side and to follow any schedule that the court might implement regarding visitation?
Yes, I'm willing to.
Do you feel like Stephanie should continue to live with you?
Definitely.
Okay. Do you have any concerns if the court were to grant Mr. Getz's request that Mr. Getz have sole legal custody and Mr. Getz determine where the child lives? Do you have any concerns regarding that?
Yes, because over the years, even before I met Michael, he was
Don't
homeless.
get into that.
Okay,
Don't get into
sorry.
that.
He has a history of not being stable, in my opinion. Stephanie's made some comments as to the way the room looks. She said, Mom, I don't want to sleep on the floor with the rats.
Have you ever been inside Mr. Getz's home?
I have not. Stephanie.
But it's your desire that the home be suitable and Stephanie have her own bed and so forth. Is that right?
Yes, sir.
Okay. You finished with those, Mr. Getz? Okay. And Ms. Strickland, I'm going to hand you Mark as plaintiff's exhibit number 2, and after the real chart. Collectively, these photographs of Stephanie and friends and family that you've taken over the years.
Yes, sir.
Okay, and with those photos fairly and accurately depict Stephanie interacting with those friends and family, would they be helpful in illustrating your testimony?
Yes, sir.
I move to introduce plaintiff's exhibit number 3 in evidence.
All right, so see.
Birthday parties and friends and family.
first witness in one last exhibit.
You may.
Strickland and what I marked as plaintiff exhibit number 4. Forfeit those, please.
A certificate from Aiden Elementary saying that she qualified for a fit kid. She had to run so many laps during the school year. And fitness is important to her.
And what was that entitled, Stephanie, to?
I never cashed in a Subway voucher.
And that's something that she's kept.
Yeah, she didn't want to spend it. She said, Mom, she didn't want to give it up to them. I said, well, I'll take you to Subway anyway.
Objection sustained. We never talk about food in this courtroom after 10:30.
She didn't want to give up the certificate, so she wanted to keep it.
Okay, please, plaintiff exhibit 4.
All right.
And, now, how much time do I have left?
Oh, let's see. You got,
12 minutes, maybe.
One more?
8 minutes.
Okay, or less. Okay, those are my questions for Ms. Strickland. If you'd answer Mr. Getson's, please.
All right, Mr. Gibb, you got about 11 minutes left, so you may ask her any questions you wish to do.
Ms. Strickland, can you tell me how long we've known each other?
Since 1998, 97 maybe.
And how did we meet?
We met in a bar.
We were drunk sitting on the bar stool.
Objection.
Yeah, sustained. We don't need to get into all
And,
that.
during this time, how well have we got along?
Since we've met,
And I would object to any testimony, again, going beyond the order. It opens up a whole can of worms.
Remember, we're talking about 2002 till today.
Our current situation is based on our relationship, and I'm trying to establish what kind of relationship that is.
I'm not concerned about what it was. I'm concerned about what it is now for purpose of visitation, not what it was.
Ms. Strickland, do you think I'm a good father?
no,
And why?
because you have not tried to take care of your family like you were supposed to do. I think you love Stephanie. I do believe you love her in your own way. The fact you filed for custody after I got child support, after 5 years, I didn't even ask for child support. No, in my opinion.
During that time when you were asking for child support, why weren't you concerned about settling the custody?
Because it was not my place. I had sole custody. It was my understanding that it was your place to do that. I had sole custody of her. So I had no reason to take it back to court.
And I think it's important for her to have her father in her life every day,
You didn't take it back to court, so I didn't know it was important. It was not my place to do it.
but you could,
Certainly I could have,
but you did not.
but I did not, exactly.
Isn't it true that our problems in our relationship is based on your sexual promiscuity?
Objection.
Well, sustained.
Isn't it true that the majority of the arguments and problems and tensions and the reason we split up was based on these actions?
Sustained. We're not talking about why y'all split up. We're talking about custody right now.
Right, and this is a concern of mine.
Well, let me say this. It's always a concern to the court when people don't let go for purposes of not their personal relationship between each other, but between them and the child, whether they can be the proper parent to supervise visitation and make sure the other parent, that they get over the past and make sure the other parent gets what they're supposed to do as far as visitation, okay? So I don't really need to know how y'all weren't very, it's obvious that you're here because you didn't get along, so I don't need to know something happened 8, 9 years ago.
Ms. Strickland, are you on any medication now?
Objection.
No rule.
I take medication for ADD, Vyvanse.
And your condition for ADD, has it ever hindered your ability to take care of your daughter?
Never.
On an occasion, whenever when you have problems with your ADD, what issues, what happens? What is the result of your ADD in relation to your daughter?
Objection, that assumes the fact not in evidence, which is there are problems.
Can you repeat the question again? I'm getting a little bit off track with the question.
Trying to establish,
So just repeat the question, and I'll make a determination whether or not you can ask it.
when were you diagnosed with ADD?
95 maybe.
Have you been on medication since then?
Not until Stephanie started.
So when?
Not until my child started.
Before you started taking medication, isn't it true that there were a number of times when you were unable to control yourself and take care of your daughter?
No, if you remember, I financially supported us, so,
Referring to physical care, not money.
no.
Isn't it true that on a number of occasions, one involving you in which, and what I believe was a result of your ADD, you were unable to take care of your daughter, and I was forced to be able to step in and take care of her?
Objection. This, again, in terms of the timetable, if we're talking about prior to October 2002, the same objection as previously.
What is the,
Sustained.
what
We
is
can't talk about anything prior to October 2002.
Right, okay, referring to things that I believe are going on in the home that I'm concerned about. That ADD affects her ability to take care of the child, and she relies on her mom and dad to do so.
Well, you can ask her about that.
And what are the results of your ADD that forced you to take medication?
It's a long-term, it's not a short-term problem. I started taking medication when my child was diagnosed because I figured I wanted to know what she was going to take. I wanted to know how it was going to affect her. I did not want to give her something that I myself would not take. And it's not a problem per se. It helps
Helps what?
long-term things.
Don't you have moments of uncontrollability and results of that?
No, I do not.
Have you ever been denied employment for a failure of drug test?
Yes.
Whenever we came here in 2002, did you invite me here?
No.
Why did I come?
We were being evicted because I was paying the bills and I was not getting to work.
No, again, we're going beyond the October 2002 order.
Okay, in 2002, when we were here, was I here based on your invitation?
Invitation, no. Necessity, yes.
Your father and you, do you remember y'all two sitting down with me and asking me here?
No. I have emails to the fact that no.
What was our relationship arrangement in 2002?
Objection.
That's sustained.
Were we engaged?
Sustained.
No.
Well, we get into that. We're talking about right now. Whatever happened between y'all two is a long time ago.
Sir, it's a character statement. It's about who the person is and a repeated long-term pattern of events that seem to be like this that affect us today.
Just a guess. I learned a long time ago when two people split up, there's two sides to every story. Y'all been split up 7 years ago. What's most important right now is parenting your child apart. Okay?
How did I end up on the streets in 2002?
Objection. Did you hear what I just told you?
Sir,
What's important is right now. If you continue to ask those questions, I'm going to stop you and not allow any more cross-examination.
have you, the evidence that you submitted today, these things here, have you ever given me anything like this before?
I have given you school pictures every year. I've made sure I forget.
But have I ever had any?
And you've never asked. No, you've never asked.
Have you allowed me any input in your decisions for our daughter who's been
Where to visit. You've had the opportunity, but your and I communication's not so good, so I just,
have you allowed me to have any input in the decision process for our daughter?
I think allowed is the wrong word to use.
Have I been able to have any input in the decision for our daughter?
You could have.
How? I believe that's no.
No, you asked her how, right?
How, if you had been more able to get along with people and not be so confrontational with people, we could have worked it out, certainly.
Was it your intent to allow me to have input in our daughter's life?
It was my intent to raise the child to the best of my ability and make sure she was happy and healthy and safe and had a place to live. That was my intention to have family.
Was it your intent for her to have her father in her life?
Certainly.
How?
You're here in North Carolina because my father went down and got you, but paid for it for us to move down here. You're here because of this, of my family. I want her involved in my life. My father
Come on, let her finish.
has done 3 visits a week, interrupting his day for 7 years to allow you to have visits with the child because it was in her best interest.
Why does he have to do that?
Because you had threatened to leave the state with our child, and so the court ordered supervised visits 3 times a week. Judge Wood.
Isn't it true that we brought our daughter here so she'd have family? I didn't have an attempt to try to leave. Did I ever attempt to make anything to leave?
The statements were made, the threats were made.
What?
You were going to,
Can you give
the
me some
exact quote was, I'm going to take this child and you and your rich family will never see her again. That was what you said to me back, that's 2002. Let me go that far, please. I don't want to get into that. I don't want to get into that, seriously.
And so Mr. Strickland, as you say, being inconvenienced by being forced to bring my daughter to me, why did that happen? Why is that like that?
Because it was court-ordered supervised visits. I had a DVPO against you. My father was more comfortable, and he asked the court to please allow him. He volunteered. Instead of us having me at the halfway house or sheriff's office, he volunteered. So you could see your child.
Since the DVPO has expired 4 years ago, why haven't you allowed me to be in her life?
You have not petitioned the court to do so.
I do not believe it's required.
They can't tell her anything, you only ask her a question.
It is not required after the DVPO expired, and you could easily allow your daughter to be, her dad to be in her life. Why didn't you?
I figured if you didn't care enough to petition, it wasn't my place.
But it was not required to petition. All you had to do was allow me in her life.
You're telling her something, you only ask her a question.
Since it's not required to petition, why wouldn't you allow me in her life?
We did allow you. It was your place to file, and you know how to file. You filed all this stuff yourself. You could have done it anytime. We have tried to get you involved in her sports activities, any special occasion at church. We above and beyond, as you said, in violation of the order. Things like that is why we did not.
So for the last 4 years, although it was not required, you have maintained the 3 times a week visitation and not allowed me to come near or call or be around my daughter outside of that. Is that true?
No. There's oftentimes in the week, if there's something going on, that my dad will say, hey, Stephanie wants you to go to a soccer game, and you've been.
What percentage of the meetings would you say that is?
It doesn't matter. It can be 1. It's not ordered by the court to do so.
Do you not believe that a father should be in his child's life every day?
No. It would be nice,
Then why wouldn't you?
but it's not possible.
You have about 1 minute's worth of
Not
questions.
possible.
Do you have a history of sexual abuse in your family?
No.
Objection.
Haven't you talked to me about sexual abuse with Chip?
No.
Where's he going with that?
I have no idea.
That I'm concerned about my daughter being in that household.
If you were that concerned, you would have filed something 7 years ago.
Has there been CPS investigations of my daughter? Child Protective Services?
1 time, yes.
And what was the reason?
A small bruise on her thigh.
I saw the bruises on her back.
That's all right, then you gotta ask her questions.
Wasn't there multiple bruises on her? Weren't there bruises also on her back?
No.
I also had subpoena Ms. Strickland,
Yeah.
Chip and Ms. Strickland. and her
You can
mother.
only ask her questions.
I was just gonna say, the time I have left, is that also for everything, or just her?
You got about 20 seconds left in your part of your case.
What would you like to see done at this point to be able to take care of our daughter?
I would like for her to see you every other weekend. Holidays, we can work it out. During the summer, I would love for us to be able to get along and communicate, because that's what Stephanie wants, and you're her father.
And based on our past history of having a hard time agreeing on things, how should we handle that? What would you like? Isn't it true that one person should be in charge of another if we can't get along, whether it be you or me? The two of us disagree and tears her apart.
All right, Kelly,
I don't
one more
understand the
question.
question.
You have to ask one more question, and that's it.
What would you like us to do in times when we disagree? How do we handle our daughter?
I would have to make the final decision, since I've been with her for 7 years and been her primary caregiver, and she'd be living with me. I would hope we could work it out. Certainly, I'd be willing to try. We can, do what we can, but this is the bottom line.
Thank you.
You may step down, thank you. You may step down, thank you. Any further else?
Yeah, I would call Pat Chapman.
All right.
I think I have 12 minutes.
11 minutes. More like, maybe a little bit, yeah.
Is that the first testimony about you as to how she mentioned on that?
All right? Yes.
Good morning.
Good morning.
State your name, please.
Pat Douglas Chapel.
And Ms. Chapel, where do you live?
5158 Harris Road, Aiken.
And are you married?
Yes, sir.
And who are you married to?
My husband is B.P. Chapel, retired football coach at Aiken High School.
And do you know Sherry Strickland and her family?
She is my head.
Okay. And how much contact would you say you've had with Sherry and Stephanie and her family over the last several years?
On a weekly basis,
Okay.
at least weekly.
Okay. And is that contact in her home, your home, or does it just depend?
In her home, my home, her parents' home.
Okay. Church. Do you go to Elm Grove?
Yes, sir.
Okay. How would you characterize your family in terms of being close?
We're very strong. We are very strong.
And have you then had occasion to meet Stephanie? Can you tell us what kind of child she is?
She is a well-adjusted, healthy, invigorating 9-year-old. Inquisitive,
What kind of personality does she have?
loving, kind. She calls me her Aunt Pat Pat.
Can you tell us what your observations have been in terms of how Sherry Strickland and Stephanie get along with one another, how they interact?
Remarkable. She's an excellent mother, in my opinion.
Okay. And how does Stephanie seem to respond to her mom?
Very loving, very loving.
Those are my questions. Thank you.
All right, you may step down, thank you. You're out of questions, Mr. Yeah, it's time wise. All right, anything else?
Yes, sir.
Left hand and raise your right, okay?
Is that the first testimony about the truth, how true, and truth of life?
All right.
State your name, please.
Joanne Elks.
And Ms. Elks, where do you live?
I live 3268 Washington Road, Aiken.
Okay. And what kind of work do you do?
I'm a pharmacy technician.
And do you know Sherry Strickland?
Yes.
And how do you know her?
We worked at the hospital together.
Okay. So how long have you known Sherry?
About 6 years.
And during that time period, has your knowing one another, your relationship extended beyond just work?
Yes.
And how often have you seen Sherry over the years?
We talk every week. If we don't see each other, we talk every week and try to get together on the weekend sometimes and do things together.
Have you then had an opportunity to meet Stephanie?
Yes.
Can you describe Stephanie, what kind of child she is?
She's very loving. She's very kind, well-mannered. She loves crafts and arts. I have a son, a year younger, and they get along very well. They like, like as far as things like that, the crafts and arts and stuff. It's really on there.
How does Stephanie get along or interact with her mom?
Very, very good. They get along fine.
Can you tell us what kind of mom Sherry is?
She's very attentive to what Stephanie is into, whether, any kind of question Stephanie has, that is, question, how does this work, what does that do? She's very attentive.
Does Sherry have a craft room in her house?
She does.
Okay. And what is that exactly? What is a craft room for those of us who may not know?
Well, it's like the playroom, and then she has this thing set up that's got all different glitters and different things that she can make things. We like to go to Michael's.
Is that something that you think Stephanie also participate in the crafts? Does she seem to enjoy that?
Yes, she does.
And how about your son?
Yeah, he likes it too.
Okay. All right, those are my questions. Thank you.
All right, you may step down. Any further answers?
No, Your Honor.
All right, I hear you all. Both of you have 2 minutes apiece. Who wants to go first? All right, kids, you can summarize your case. You have 2 minutes.
I appreciate the opportunity to be here. Obviously, people don't always get along. We have chances like this, and public servants, they can step in and try to make the best of a bad situation. And unfortunately, this is a bad situation. Despite the fact that she might have a nice room, my daughter might have a nice room, and she luckily has some family and stuff, she does not have her father. And it has been repeatedly shown that even without the need of a court, the Strickland has not fulfilled its attempts to be a family. It is necessary for the court to step in and take action. I am Stephanie's father. I'm not trying to keep her from anybody. It would be in Stephanie's interest and everyone's if I am in control of my daughter, Stephanie Ann Getz, I am Michael Getz, because Strickland chose not to be a part of our family. It is a mistake to continue as it is. And I am concerned that shared custody or visitation or those other arrangements will lead to constant conflict. I ask the court to give me custody of my daughter, at least to be able to allow me to be the one in her life that makes the decisions. Anything short of that will hurt my daughter, I'm convinced. I apologize for having to be here and say the things I've had to say about Ms. Strickland. I hate it. Despite these differences, I have always loved her, and I will respect her as the mother of my children. We must make decisions that are best for my daughter, not for either one of us. In this current situation with Ms. Strickland, either in control or shared custody, does not work. I ask the court to give me custody of my daughter and sole authority over decision making. Thank you.
Thank you, Mr. Getz. All right, Mr. Duke.
Your Honor, the evidence that's been presented is that this is a remarkably well-adjusted child, doing well in school. All the things you look for in a home environment exist here. You've got a mother who is gainfully employed and has been. The child's got a very long extended family, lengthy extended family, great-grandparents, grandparents, aunts, uncles, second cousins, first cousins. She's performing well in school. She's active in her church. All the things that you look for to see that a child is healthy. Ms. Strickland is not intended coming in here that Stephanie doesn't love her dad and her dad doesn't love Stephanie. But, of course, you've got a fairly long period of time where, albeit the contact is not what we would call a normal routine schedule, something was implemented by Your Honor back in 2002. The evidence has been that the Stricklands have complied with that order, and then some over the years. 1,000 visitations, and Mr. Strickland, Marvin Strickland, is the party that's been facilitating that.
Mr. Guest knows how to file motions. Mr. Guest knows how to do a lot of things. Not one single contempt motion in the file, not one single motion to modify until most recently, and coincidentally, that was after a child support petition was filed. Ms. Strickland isn't coming in here telling me today, don't modify it. She's told you what she thinks would be best at this point based on what is good for the minor child, who will be 10 years old in December, and a 10-year-old being in the custody of physical custody of Mr. Guest during visitation periods is a lot different than a 3-year-old, a 4-year-old, and so forth. Ms. Strickland at this point feels okay with it. She's certainly willing to, she told Your Honor what she's willing to do. This is not a lady who's coming in here saying no contact, no contact, no contact, and she didn't say it, never has said it in this courtroom. And I will say to the court that you can't overlook sometimes with history how things evolve, and perhaps Mr. Guest is now in the position, if he were not in a position to take care of the child, albeit it's not a perfect environment, Ms. Strickland wouldn't be advocating or stating that she was okay with it. We trust Your Honor's judgment. What we don't want is obviously Mr. Guest has sole legal authority over this child. That's absurd from a legal standpoint, factual standpoint. This is a man who filed a motion to stream live video of this custody proceeding on the internet. You can take judicial notice of that. This is a man who asked that Ms. Strickland's parental rights be terminated, knowing that this lady's been financially responsible exclusively, really up until sometime in 2008. To take those positions ought to give the court some pause to wonder really who is trying to alienate or restrict or limit or eliminate the relationship between a child and another parent. Ms. Strickland is overlooking all these things. She's coming here and told Your Honor what she thinks is good for Stephanie, not because it's what she wants, but because she's telling Your Honor Stephanie wants to have contact with her dad, and we trust the court to make the right judgment.
All right, the party will stand up, please. A couple things. It's the premise that you approach this case is somewhat puzzling to the court. You talk about the original order and how it limited you, and you've taken out context the facts at the time. That's why courts do orders. That's why this court does orders. Even to sometimes, and a lot of times, do its own orders to make sure the facts are in place so that some judge, as in this case, 7 or 8 years later, can look at the order and determine what was going on at the time in the judge's mind when he entered the order. Fortunately, there's a very factual order here that's laid out. In a situation back in 2002 at the time of this hearing, which was a temporary hearing, was that you were homeless. You had no home. And at that time, the court was in a position, there was domestic violence alleged. So you had no home. There was domestic violence between you and the respondent in this case. Hold on. That's what the court found. And at that point, the court had to determine where to put the custody of this child. In a temporary order, those are the facts that existed then. And in reality, the court had no choice. It had no home. You weren't in a home. How in the world was it going to put a small child, who at the time was, 2 or 3 years old, in your custody, and you were living on the streets? Secondly, you were threatening at the time. There were some allegations. The court found that those allegations were being made that you were going to remove the child back to the state of Texas. So, at the time this order was entered, there was a valid reason for it. And the order says very specifically in finding number 4, and this was my order, this is a temporary order. Either party may petition the court for an entry of an order relating to holiday visitation should the case be not resolved prior to November 1st, 2002. A month earlier, in October, when this case was heard, the court, in this case myself, put a provision in there because it was concerned about your ability to have holiday visitation, and was willing to have a hearing to determine that, based on maybe you would get a house or you'd be living somewhere. And I haven't heard any evidence that in this case there's no order in this to show me that was actually, that you actually asked the court to do that. So, I understand your argument to some extent that, well, as a mother, you should have did that. But in the last week and a half, I've done 9 pro se orders. I have to do them. These are orders, which means pro se means a person came in like you've done yourself, on your own. It happens all the time. We've had family court now, 2-3 years maybe? People file motions on their own all the time. If this matter was important to you, you could have done it on your own. Very easily filed a motion. Everybody does it. Everybody in the street knows how to do it. Trust me. When we want to show people's computers, I can show you about 150 pro se orders I've done over the last 2 years of people who filed their own motions. You could have done that to change this.
I'm sorry, file what motion?
To do what you just did in this case, to file a motion to modify custody. Now, let me tell you something. You're sitting here making her a villain, but I want to tell you something. Yes, you are.
Speaking the truth.
No, I am telling the truth. Let me tell you something. I looked at one of these pictures, and and it struck me. On this picture of the piano is the same picture that you showed me of you and your daughter. Sadly, you want to know how many times I see that? I don't see that. Most of the time when I get pictures of one parent and the child, I never see the opposing parent appearing in the picture. I make a mental note of it all the time. I say, wow, there's another picture without daddy in it, or there's another picture without mommy in it. And yet here's a picture of you in a prominent place, sitting on top of a piano, of you with your daughter. You know what? That says more than the whole testimony in this case by either one of you. That tells me she's not trying to keep you out of your daughter's life. Because I'm going to tell you, I see cases where it's a scorched earth policy. The other parent might as well not even be living in the eyes of the other parent. That says volumes right there. Now let me tell you something. You deserve to have more visitation, but at the time that this order was entered, it was the right thing to do. And if you operated under this order, you did so because either you wanted to or some other reason that I don't understand. You could have filed for change if you wanted to, and you didn't. Now, you haven't been living on the street for 5 years.
As soon as I was able, I'm here.
Well, let me tell you something. I'm going to modify the custody, but I'm not going to give you sole custody. The only person who's come into this courtroom and talk trash about the other side is you. Well, you know what? That happened 7 years ago. Right now, you two have a daughter. If that daughter is the most important thing in your life, you would have spent your time today talking about you and what you can do for the daughter. You wouldn't try to go back time and time and time again back beyond 2002. I can't find at this point that you're in a position where you can act responsibly and care for your child and make sure that she gets to see the child like she should. With all the anger that's built up in you for her family, it wouldn't happen. I mean, you need to address those problems. I have some concerns that you, and I hope that when this visitation starts, that you decide to rise above your hurt feelings and be the parent you need to be. Because if I find out that you start talking about mom and her family to the child, there's going to be some problems for you. Okay? You will abuse, in my mind, your visitation privileges, and I don't believe you want to do that. Right? Is that right? Excuse me? That's right. And you're not going to cut her out of your life. And I'm talking about her mother. All right, so Mr. Duke, I want you to draw this order. I want to start every other weekend, I guess from 6 p.m. on Friday to 6 p.m. on Sunday. That I'm not exactly sure how the transfers take place. I don't know any suggestions that you have in talking with your clients.
We're thinking of maybe a neutral location, somewhere halfway between Farmville and where Ms. Strickland lives. Fast food restaurant, something like that. I think Ms. Strickland wants to take her father out of the middle of it. So we feel more comfortable with that.
All right, what about the McDonald's located at Pitt Community College, the new McDonald's? You know what I'm talking? Right across from Pitt Community College?
Okay.
Okay?
Fine with that.
I don't know, you got a car, don't you?
Yes, sir.
Well,
He's coming to me.
you're going to do like every other parent does, and that is you're going to meet halfway when you live in two separate towns. Okay? It's part of the deal. All right? So you're going to meet at the McDonald's located at Pitt Community College. That, let's see, every other weekend, let's see, the child's going to spend Thanksgiving with the defendant, with him during odd number years, with the plaintiff during even number years. I'll split up the Christmas holidays as far as, I don't know either way they want to do it. If they want to, one have Christmas, or they can split the day up. I don't care how they want to do that. So, would y'all rather split up Christmas Day?
There's no right answer in this. It's kind of hurt my daughter to want to part like this no matter what. I'm willing to do whatever this makes sense.
I mean, I hope at some point work out if it comes to Christmas.
Are you contemplating dividing up the holiday consistent with the school schedule, or
Well,
just the individual?
I do it one of two ways. They either split it up like if there's 12 days, they both get 6, and then they alternate front end, back end every other year, or they split the holidays, but then in a microcosm, there's Christmas and Christmas Eve where that is actually split. One party has a child on Christmas Eve from 2 to 12 the next day, or from 12 to 12, and then goes with the other, parent. A lot of it depends on the customs of the family and what each family does.
It's not possible for us to have it together.
It don't sound like it to me.
I mean, it is not.
As I had mentioned to you, I can't mention mediation, but I told you that I'm hoping one day to be allowed to come to Christmas dinner, but you have to build trust up. It can't just happen. So let's try it for now. And if I decide one day, I'm afraid now, if I decide I'm not going to meet you at McDonald's, I want to take you to your house, I'm going to be in violation of order. I mean, come on.
It's not me.
I'm concerned about that.
Mr. Duke?
Ms. Strickland indicates that her family's tradition, I think, is on Christmas Day most years.
and that would probably be after 12 noon on Christmas Day.
All right, so you'll have the child from Christmas Eve at 12 o'clock. This will all be in order till 12 o'clock, Christmas Day. You'll split the holidays and rotate those one side will have the front side and back side the next year, you know. Your client will have the pick. I don't care either way since he has Thanksgiving.
Okay.
And then Christmas Day will always be Christmas Eve from 12 till 12 Christmas Day. And there's going to be a transfer, okay? And I'm going to allow the Christmas Day transfer to take place residence to residence, okay? So on Christmas Eve, she'll take the child to his house. Christmas Day, you'll take the child to her house at 12 o'clock, okay? Got that?
I think Ms. Strickland would probably, and I mean, he's going to have to balance, you know, obviously the family tradition, but also, if I understand what you're saying correctly, under that scenario, it would be every Christmas Eve with Mr. Getz. Is that what you're saying? I don't think really she would rather sacrifice every other year potentially.
Okay, so you'd rather rotate that too?
Yeah, what I would say is 1 year the day school lets out until Christmas Day at a certain time with one parent, and then the other parent is Christmas Day until the day before school resumes and flip it.
So just split it at 12 and go from
Right,
1 to, okay,
exactly.
that's probably easier. That'll be fine, I don't have any
That
problem.
way, take some good out of bad.
Yeah, okay. I think that's certainly easier for each side to remember. Yeah. All right, birthday, each party shall have 2 hours on or about the child's birthday to schedule a get-together. Again, hopefully one day you'll all be able to do that together. Each party shall have 2 hours on or about their own birthday to celebrate with its child. Any additional visitation that the parties can agree on. Defendants to have a week in the month of June, 2 weeks in the month of July, 1 week in the month of August. He's to give her notice 90 days prior to, let's say 60 days prior to end of school, to the last school date, to give her notice as to the weeks he's going to choose. That those weeks cannot include the first full week after the end of school, nor include the first full week prior to the beginning of school. That let's see, is there any special tradition that the child has with y'all's family during the summer? Like there's a like fourth get together somewhere where they all get together or something like that, or is it can be flexible? Okay. All right. Father's Mother's Day, will be spent with the honored parent. Easter break can be spent in odd years with the defendant, even years with mom. And then whoever doesn't have that Easter break week will get Good Friday to Easter Sunday. Okay? So basically the rest of the week will go to the parent that doesn't have Easter and Christmas. Easter, Good Friday through Easter. Obviously, they can work out any additional time that they're agreeable to. That when one of the parents is, this specifically to the plaintiff, when the plaintiff is unavailable for whatever reason, wants to, Ms. Strickland, if you want to, you have a business trip or something, or visitation, there's generally a right of first refusal where you have to give the other parent the right to have the children for an extra weekend. In my situation, that does not occur if you want to leave the children with your parents, okay? So if you want to leave, that counts as you, okay? I don't require a parent to give the child to the other parent during their normal visitation weekend if they're going out of town, as long as the grandparents have, okay? This is the way I feel. I feel very strongly about grandparents. So, grandparents can trump you during her weekends if she has a business trip. She does not have to have to go to you. They can stay with grandparents. Okay? Usual provision about allowing the child to telephone the other parent, reasonable times, reasonable intervals. That's defined in my book as once per day is reasonable, and for 15 minutes. Okay? Up to 15 minutes. Once a day. Neither party shall telephone the other party for any other reason. Once you exchange today email addresses, all communication will take place, at least for the time being, by email. So there's a record of any communication between the two of you. Okay? Remember, anything you say by email usually comes back to haunt you in court, so make sure when y'all are not happy with each other that you temper what you're saying, because, trust me, I see them all the time.
So we're not, can't talk on the phone the same?
I don't want you to talk right now. I think you need to communicate by email.
My daughter can call me.
Your daughter can talk to you anytime, sure. And of course, if the daughter calls either one of you on the answer machine, that you're going to encourage the child to call the parent that has called them back as soon as possible, okay? Each of the parties, of course, the plaintiff will retain, we'll have joint legal custody, and well, she has sole legal custody right now, so I'm going to leave it that way at this point. Each of the parties shall have free and unrestricted access to all school medical records, okay? So you got to do whatever you can to allow him, he can allow to see medical records. You'll have access to those. Both parties have fostered a feeling of affection between them and the other party. You're not to say or do anything that reasonable effect would be to estrange the minor child from the other party and to impair the child's high regard for the other party. Means you can't make disparaging remarks about the other party. Okay? You can't do it in the presence of the child. You can't be talking to somebody else on the phone about how sorry they are, and the child hears it. You'll be in trouble with me and probably subject to contempt, which generally means going to jail. No smoking in front of the child. Neither party shall allow a person of the opposite sex, other than a family member, to stay overnight while the minor child is residing in the home of the party in question. Neither party shall smoke or allow others to smoke cigarettes in the respective home. Either party shall purchase spyware for their computers for the purpose of eliminating and blocking the reception and transmission of all inappropriate and harmful material, in parentheses, pornography, via the internet by the respective home computer. I want all that blocked.
Personal supervision, take that place. We don't have a
Excuse me?
Can personal supervision be sitting there with her?
No, sir. I want computer spyware blocking it. All right, want that put in place within 30 days of signing of this order. Can I keep the other party advised as to your current address, mailing address? Shall notify the other party at least 60 days in advance of your intention to move your primary residence outside of Pitt County. In the event that one of the parties moves to a location outside of Pitt County, the minor child shall continue to reside in Pitt County. until an agreement has been reached or a judicial determination has been made with regard to the physical custody of a child. Can't leave the state without the child. Mr. Getz, I'm not going to say you're going to do this, but you don't want to have family outside the state. If you go to the state of Texas, and I want a provision in this order that that I have found that North Carolina is the home state jurisdiction for the purposes of this child under what's called Uniform Child Custody Jurisdiction Act, which I'm sure that the state of Texas has ratified as well. And all custody issues, if you were to remove yourself from the state, would have to come back to be heard here. Okay? So, and the state of Texas, under the same law, would defer to the state of North Carolina. Okay? All right, both parties shall, if you enroll the child in any extracurricular activities that would involve the participation of the minor child during the times when the other party is scheduled to have a child, then you've got to communicate with them, like soccer, stuff like that, softball. If there's any issues about it when y'all two can't agree, then you have to come back to court. I'll make that decision. Let's see. If you can work it out, you can certainly swap dates and times and whatever. Hopefully y'all can do that. Whenever the child's traveling out of state, it will be one of y'all. The traveling party is going to notify the other party reasonably in advance of the trip and shall provide the other party with a telephone number where the minor child may be contacted, okay? Remember, if you're going to take the child out of state to live, like you're moving, then the court has to be involved. Obviously, if you're going to Disney World or something. As long as you let the other party know and they got a phone number so the child can talk to them, that's okay with me. Okay? Anything else? Am I leaving out anything?
Sir, clarification.
Sir?
Clarification, please.
Sure.
On the sole legal custody, you mentioned where you said shared and then legal. Does that mean that I don't have any say in my daughter's life? Like her medication she's taking, I don't approve of?
Well, you know, unless you get a doctor to say that's not good, I'm not going to let you play doctor with this child. And that is exactly the reason why I'm going to leave sole legal custody with the mother.
I use it as an example to explain that I'm making a decision in her life. Do I have say in that?
You certainly should communicate with her, but the final person, and I urge both of you as part of this order to communicate with each other concerning final decisions.
Or she goes to school, stuff like that.
Well, you can communicate with her. You disagree with that wholeheartedly, then you probably can file a motion. But if I thought you two could work together, I would, but I'm not sure. Well, I don't think you've done it yet, so I'm not willing to do that. Both parties shall confer with one another and try to reach a mutual decision with regard to all major decisions affecting the best interest and general welfare of the minor child, including schooling, health, medical treatment, counseling, religious upbringing, organized extracurricular activities. In the event that the parties are unable to reach an agreement between themselves with regard to such matters, both parties shall consult with the minor child's counselor if one exists, in an attempt to reach an agreement with the assistance of said counselor. In the event they are unable to reach an agreement after conferring with the child's counselor, if there is one, then the issue in controversy may be submitted to the court for a judicial determination upon the request of either party and proper notice to their side. Okay? So certainly you can discuss by internet your issues, but I will not allow you to change this child's medication without medical approval of it.
That's what I would like to see.
Well, you can certainly look at the medical reports because you have access to them and make some determination in talking with the doctor. But we're not going to have a child here who's being refused the medicine on one side, and then you go home and the child's all of a sudden having the medicine and she's jumping all over the ceiling at the schoolhouse because she's not receiving the medicine. Exactly. Okay? Anything else?
so based on this, I'll get this paperwork and I'll see all the things we just talked about, and it'll be written down, I can see it.
So you write down, you'll have it.
Yeah. And that, if we agree on things beyond that, it's still okay if we say, if we decide to meet more, or if you have anything, everything's okay, right? I mean, this is what we go to if we can't get any other way.
No, this is what you operate by.
Right, but I mean, we have discretion, I'm asking.
If y'all agree.
Able to be together and not argue, we can do it, I'm trying, that's what I'm trying to do.
The ball's in your court on that.
Right, I just don't want to be told later that, well, the judge said, no, that's what they've been saying for 7 years, you can't do it.
Well, I mean, if it's something you can't agree on, you can't do it. Then you have to come back to court and ask the court to change something.
Right, but I mean, if we agree, we can go in addition to what you offer him.
We.
Right.
If we agree. If you two agree, yeah, you can do wonders. If you act like good parents, yes. There's big emphasis on we, not what you think. We.
And how long is this in effect? Is that long?
Until that child turns 18, unless it's modified by this court.
And is there a limitation on attempts to modify?
You're going to have a substantial change of circumstance, and there's a thing called a Rule 11 motion, which means if you file a motion which I consider frivolous, I can make you pay the court costs, make you pay his attorney's fees.
To avoid that, so what would it be?
You better come up with a substantial change in circumstances.
I'm just trying to understand what would be those, I want to comply.
Well, I can't practice law for you, but just think of what that means, substantial. Now, it doesn't mean nitpicky.
Right, yeah. I'm just saying I might have a different opinion of what's substantial, and I'm just trying to make sure I comply. I'm only saying that if things don't work out, and there's still...
Let me just tell you this, I can't tell you practice law, but if your definition of substantial differs from mine, then you will be paying attorney's fees. All right? So if there's any question in your mind about what Judge Blick thinks, then you probably don't need to bring it. A substantial change. You know what that means. You teach in school, you know.
Sir, I plainly have a different agreement, a different understanding of what's important to my daughter. That's more important to me than what everybody else sees. That's what I'm saying. I want to comply. I'm trying to understand, and I won't make problems. But if there was a circumstance where I felt like I need to come back to court, I'm just trying to understand.
Might be a good idea to talk to a lawyer. Okay? You can always just ask their opinion. If you're going to still represent yourself, you can talk to one and they'll tell you whether they think you're in good shape or you're not.
I've just tried every one I can think of, and I don't ever get any help unless I pay them $4,500, and I'd rather get back to my daughter if I had to pay that.
All right. I mean, you certainly can go to East Carolina, you can go to the law library at Pitt, and you can look up and read cases and get some idea of what a substantial change in circumstances. But it is what it says, a substantial change. All right? This order is a substantial change. You've gotten yourself on the right road. Okay? The original order, you were homeless. You've gotten yourself on the right road. That's a substantial change to allow change in the custody situation. That's the kind of thing that needs to take place. Okay?
Thank you, Ron.
All right. I'm going to let Mr. Getz go first. And we're going to take a little bit morning recess for a few minutes, about 10 minutes restroom break, and we'll get back to see where we are in the next case, okay?